Case laws. We have 6 main case laws that us as law enforcement officers must know the inside and out of for our day-to-day policing. These case laws are Tennessee versus Garner, Terry versus Ohio, Pennsylvania versus Mims, Wyoming versus Hughton, Carroll versus United States, and Miranda versus Arizona. There are additional case laws that may be utilized, but only at the Supreme Court level. No state case laws can be utilized in our courts on San Andreas. Tennessee versus Garner. Under the Fourth Amendment of the United States Constitution, a police officer may use deadly force to prevent the escape of a fleeing suspect only if the officer has a good faith belief that the suspect poses a significant threat of death or serious physical injury to the officer or others. Key points of this case law is that deadly force is only authorized to prevent the escape if they believe that if they escape, they will continue to cause serious injury to others or death. Terry versus Ohio. Under the Fourth Amendment of the United States Constitution, a police officer may stop a suspect on the street and frisk him or her without probable cause to arrest if the police officer has a reasonable suspicion that the person has committed, is committing, or is about to commit a crime and has reasonable belief that the person may be armed and presently dangerous. This enables you to frisk an individual if you believe that they have committed, is committing, or is about to commit a crime, but they must believe that they are armed and presently dangerous. Pennsylvania versus Mims. United States Supreme Court decision that a police officer ordering a person out of a car following a traffic stop due to officer safety did not violate their Fourth Amendment rights. Essentially, this case law allows us to order a suspect out of a vehicle when conducting a traffic stop due to officer safety. This does not mean that anything that the suspect was doing is reason to do this. This could be something as simple as asking the suspect to exit the vehicle and stand on the side of the shoulder if you believe that your safety is compromised due to high traffic flow and you believe you may be struck by a vehicle. Wyoming versus Hughton. Police officers with probable cause to search a vehicle, as in this case, may inspect passengers' belongings found in the car that are capable of concealing the object of the search. Only containers that may hide the item you are currently looking for may be searched. An example of this is if you are looking for a baseball bat, you will not be able to search an individual's purse as it is not the same size and able to conceal an item of that size. Carroll versus United States. In Carroll, the court established the automobile exception to the Fourth Amendment protections against warrantless searches. In this Prohibition-era case, the court noted the inherent difference between buildings and vehicles. Buildings remain stationary, where cars and other vehicles can be moved and hidden before a warrant can be issued. The court held that if officers have probable cause that an automobile contains evidence of a crime, the vehicle in question can be searched without a warrant. This is mainly due to the fact that a vehicle can be driven to a different location, therefore making the warrant process invalid. Miranda versus Arizona. Under the Fifth Amendment, any statements that a defendant in custody makes during an interrogation are admissible as evidence at a criminal trial only if law enforcement told the defendant of the right to remain silent and the right to speak with an attorney before the interrogation started, and the rights were either exercised or waived in a knowing, voluntary, and intelligent manner. Key points is they only need to be read if asking self-incriminating questions. Spontaneous utterances are not protected and can be used in court. Suspect cannot be in duress, intoxicated, under the effects of narcotics, and mentally capable of understanding their rights. You have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to an attorney. If you cannot afford an attorney, one will be appointed to you. You'll understand these rights as I have read them to you. There are 4 key points to the Miranda rights that must be read prior to asking any self-incriminating questions. These are: you have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to an attorney. If you cannot afford an attorney, one will be appointed to you. After reading a suspect their Miranda rights, it's important to ensure that they understand the rights as you have read them to them.